A lot of the same investigators in the Karen Reed case have percolated over into the Brian Walshe case, and the Brian Walshe case has a lot of crazy issues outstanding.
You lost. And you know what you did.
I'm attorney Andrew Myers. This is About the Law. Joining me is California attorney Yolie Medina. Hey, Yolie.
Hi, how are you?
I'm good. Just kind of shocked that the Brian Walshe case is going to go forward suddenly. I mean, it's been on hold for all of these months. It's been not quite, but almost 3 years since the disappearance of Ana Walshe. And there are just so many issues outstanding. A lot of the issues are boiled down into a joint pretrial. The final pretrial conference has not been held yet in this case, and some people might think that legal pleadings are boring, and we tend to not read them word for word like some other people do. But in this case, the final pretrial joint memo actually raises a lot of interesting issues. And here it is, and the final hearing hasn't been held, but this is Commonwealth versus Brian Walshe, joint pretrial memorandum. And what that means, Yoli, you know, but what that means is that the court asks both sides in a case, criminal or civil, to sit down and agree on a joint pretrial. So both sides are represented in this document. And one thing that I found interesting is usually they require us to sit down and hammer out the proposed statement of facts to be read by the jury. Here's the assumption. The assumption is that the jury doesn't really, they might have read the newspaper, but they don't know what the real legal issues are. They don't know, they might have read something here or there, but we need a concise statement of the facts just to introduce the jury to what the case is all about.
And it's not sensationalized or anything, the statement of facts. It's just really factual, nothing, outrageous, just straight to the point.
Just the facts, ma'am. Just the facts. So, generally speaking, we are required to sit down with the other side, and it takes some time to go back and forth and back and forth and back and forth, but it has to be an agreed to proposed statement. But in this case, the Commonwealth came up with one, and the defendant came up with the other. So why don't I read the Commonwealth's if you would be kind enough to read the defenses? So here are the two proposals for the statement of facts to be read to the jury. Commonwealth's proposed statement of facts to be read to the jury. Ladies and gentlemen of the jury, on December 30th, 2022, Ana Walshe returned home to Cohasset from her job in Washington, D.C. to be with her husband, defendant Brian Walshe, and their children to celebrate the new year. On January 4th of 2023, Ana's employer called police to report that she was missing. Cohasset police went to the Walshe home. The defendant reported that Ana was missing and alleged that she had left the house early on the morning of January 1st and that he had not heard from her since then. Days later, police searched a dumpster outside the defendant's mother's Swampscott apartment and found clothing the defendant said Ana was wearing when she left on January 1st. Ana Walshe's COVID vaccination card, towels with red-brown stains, a hatchet, and a hacksaw. The defendant is charged with aiming Ana Walshe, unlawfully conveying her body, and misleading investigators. So that's the Commonwealth's version. Now here's the defendant's version.
Okay. So this is the defendant's proposed statement of facts to be read to the jury. On January 4th, 2023, Cohasset police began an investigation into the whereabouts of Ana Walshe, the wife of defendant Brian Walshe. At the time, Ana Walshe worked and lived in the Washington, D.C. area and would return to the family home in Cohasset where her husband and 3 small children continued to reside. The defendant is charged with causing the death of Ana Walshe, of misleading police in investigation, and of disinterment of and conveying away the body of his wife, on and after January 1st, 2023.
The interesting thing, as you said, it's got to be dry and cut and dried and just the facts. Notice how the prosecution snuck in, more details like Ana Walshe's
The
COVID
red-
vaccine. Yeah, the stuff that was found in the mother's dumpster. They added in those facts, and the defendant doesn't want those facts in. The Judge Diane Frenier, is going to have to sit down and decide which version does she go with.
Yeah.
And that'll be interesting. The next
Yeah.
thing that was interesting, they've now determined that this trial is going to start on December 1st. Of course, that's Christmas and Hanukkah and, other holidays. And they say here, length of trial, 3 to 4 weeks, full days, excluding jury selection. So hopefully the plan in court, anyhow, is to get the jury selection done by the end of November. And then the trial is going to be 3 or 4 weeks. That goes right into Christmas. Which nobody wants that, I don't think.
No, nobody wants that. But it is what it is.
So now we get into the Commonwealth's potential exhibits, and we're not gonna go read every single one of them, but this is interesting that the defendant does not agree to the introduction of all of the evidence listed below and has filed a motion to designate what specific photographs and forensic evidence will in fact be introduced. But the Commonwealth, of course, wants photographs, 1, of the home where they were living in Cohasset, 2, the defendant's Volvo SUV, nothing overly controversial quite yet. 3, photographs of digital devices, including iPhones, 13 minis, all that stuff. So, they had 3 kids, so there's going to be, devices.
Yeah.
Photographs, surveillance video, and receipts from retail stores and dumpsters associated with the stores, including Home Depot, Lowe's, Vinin Liquors, TJ Maxx, Home Goods, the Claremont, Stop and Shop, Chatham West, CVS, Walgreens. So yeah, we know that he is alleged, Mr. Walsh is to have gone into Lowe's and made a purchase of approximately $450 worth of cleaning supplies. So they want to get that in. They'll just have to lay the foundation for it.
Yeah.
And then I forget whether it was CVS or Walgreens where was his alibi, allegedly, where he said he went there. And they got the tapes from one. I forget which one. He did go into one, but the other one he did not go into. And he said he did. So that's just consciousness of guilt, I think.
Well, yeah. And it's also going to be a jury question about whether they believe. I mean, I don't think he's going to testify. Do you?
There are people out there that say he will. I highly doubt it. I highly, highly, highly doubt it. I highly doubt it. There were all kinds of rumors that Karen Reed, having given interviews to Boston Magazine, to ABC, to the local Boston 25 and other stations, there were a lot of people saying that Karen Reed has nothing to hide and she makes a great witness. She's a brilliant woman. She's going to go on the stand. When it came right down to it, she did not testify on the stand. I think she took the wise advice of her competent legal team. And I've heard on some other channels people talking about how Brian Walshe wants to take the stand. I think it'd be a mistake. I think it'd be as big of a mistake as Alex Murdaugh going on the stand and saying, I lied. Okay, so, a lot of other stuff here. There are voicemails of the defendant, text messages of the defendant and others, text messages from the iPhone 13 mini, and on and on and on and on and on.
And the search history, internet and search history from the iPhone 13, iPhone SE. Yeah.
Yeah. JetBlue records confirming that, and Uber records and Lyft records showing that she never went to Washington. He had told the Cohasset police and state police that she had gone down to Washington, and it was said that they did an exhaustive search, and she was not on any ride share, and she was not on any airplane out of Boston. So Tishman Spire employee documents, that was her employer in Washington. Federal docket. This is controversial. Federal docket in United States versus Brian Walshe. This is where he had been convicted of fraud with
For the art.
respect. Yeah, for the Andy
To the-
Warhol.
Yeah.
He sold 2 Andy Warhols for 80,000.
Yeah, that's going to be interesting because it's a prior bad act, and it's, I guess it bears on his veracity or honesty.
This is
So
one of those things
Hollywood.
that, yeah, you and I have talked about this before, how not every criminal wrong that you've committed in the past, which is on record, is admissible in court. And Massachusetts has some really specific rules. Misdemeanors are good in the last 5 years. Felonies are good in the last 10 years. And this is, in fact, a crime of dishonesty. He did sell
sold?
2 Andy Warhol prints, phony ones, for $80,000. And it didn't take long for the person he sold it to realize they were fakes. Anyhow. Oh my goodness. These are the Commonwealth's win. Well, I've said it before, and I'll say it again because it really applies in this case. Just because you put a witness on the witness list does not mean you're going to call them. A lot of times it's a bluff. But, a lot of these are keepers of the record. For example, the keeper of the record for TJ Maxx, the Norwell, Massachusetts TJ Maxx. Now, they might be able to reach an agreement. I mean, why make the keeper of records for Lowe's go in? I mean, basic under evidence law, you've got to, lay a foundation and authenticate all evidence. But I mean, why bring the keeper of records from American Express? He or she is probably sitting in some beautiful New York office right now, and they don't want to have to fly into Boston. Maybe
Now, the keeper of records or the keeper of video surveillance, they might have to bring those people in to talk about how the video was maintained and how it was not all, the chain of custody of any video, because now with AI, I think that's going to be more important than the
point.
records, because they could stipulate, to the records if there isn't any issue regarding like the records of JetBlue or records of Lyft, to
That's a
save
good point.
time.
Especially with AI, I see so much junk. I see so much junk on Facebook right now. Oh my gosh, there's just so much junk, and you know that it's AI. But that's a good point that you made. That with respect to the video, and I wonder how. I hadn't thought of this until now. I wonder how jurors will think when they see video. Oh well, this is AI, and some of the pictures are grainy. They have pictures of Mr. Walsh in Lowe's with a shopping cart, and it's really very grainy photography. I guess the camera wasn't, tuned up that well to that particular day, which is surprising because in 2023, sure, 20 years ago, surveillance video was kind of crappy, but now, I don't know. So that's, and then over on the right-hand side of your screen, the civilian witnesses, and they go on and on and on and on and on. But then Massachusetts Crime Lab personnel, and there are, I think I counted about 30 different personnel from the crime. I don't think that many people from the Crime Lab testified in the Karen Reed case. I think there were half a dozen of them, but not that many. Then get the drum roll out, please. Oh, look at this. We have the Cohasset Police Department there. Then we have the FBI. Look at this. 1, 2, 3 different FBI people. Then here we go. Massachusetts State Police. Yuri Buchanan. Remember him?
Yep.
David DiCicco. John Fanning. Remember him?
Yep.
Nick Gorino, remember him in the second trial? I didn't really understand that Hank Brennan brought him on the stand. At least 3 or 4 different occasions. Instead of putting him on the stand and getting everything out of Nick Gorino that he could, he kept saying, you may leave, reserve. But so there we have John Lannon, not to be confused with John Lennon. And so that's Lieutenant Brian Tully. So we've got on this list, we've got Buchanan, we've got John Fanning, we've got Nick Garino, we have
Tully.
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 So now,
No
interesting.
Proctor.
Oh, well, we'll get to that in a minute. Hold that thought. If I don't bring that up in the next 5 minutes, remind me,
remind you.
because we have enough to do on this. Over time, mind just gets inundated in all of this. So let's review these guys that are on this list. We've got Sergeant Yolie Buchanan. He was investigated in an internal affairs investigation, and the first thing that happened was he lost 5 vacation days. Come on, folks. That's the best you can do, because he was in on those texts. He was Michael Proctor's supervisor, and he was in on all those texts that we're not going to go into. You know what I'm talking about. Then the second thing that happened with Sergeant Buchanan was that he was kicked out of the Norfolk County District Attorney's Office. He was working out of the Norfolk County District Attorney's Office until all the you-know-what hit the fan in the Karen Reed case. Boom, he's gone. So now we get to another person who's on the Brian Walshe witness list. Detective Lieutenant Brian Tully. He was disciplined after a internal affairs investigation. He forfeited 6 vacation days. Can you give me a slap on the wrist? But then he too was transferred out of the post, as he was commander of the Mass State Police in the Norfolk County District Attorney's Office. So he was transferred out of there. And then Lieutenant Fanning, who you see on that list about 3/4 of the way down the page. Mass State Police Lieutenant John Fanning was placed under internal affairs investigation for failing to uphold responsibility of a supervisory member. That was dropped.
Interesting.
But he was investigated. So now, all right. Now that's everything above, about 3/4 of the page down. That's for the Commonwealth. Now we get into the defendant's potential witnesses. There's Michael Proctor. See him?
Yeah.
So the defense is saying, well, we reserved our right to call him. We reserved our right to call Michael Proctor, which is interesting. Whether they do or not remains to be seen. Whether that will stain the Commonwealth's case, I don't know. And then Tracy Minor, right above Michael Proctor. Tracy Minor was Brian Walshe's first attorney, and she was involved in some phone calls with the Commonwealth with regard to the seizure of Brian Walshe's electronic device or devices, and how far the Commonwealth could go in getting into those devices. Now, the judge has already ruled that there was no violation of the warrant, but remains to be seen.
Interesting.
Yeah.
So, wow. So did Tracy Minor represent him in the fraud case as well? Or?
No, that I don't know.
Oh.
That I do not know. Often it's different attorneys that go to federal court and state court, as you know.
Yeah.
I've done both, but there are attorneys that don't do anything outside of the state courts, and there are attorneys that don't do anything outside of the federal courts. So Now these are the Commonwealth's motions in limine. Maybe we did do some of this. Did we do this one to provide the jury? Okay, all right. So we did that.
Yeah, we
All
did
right.
some.
But look at all of these issues that it is contended have not been dealt with, and they've only designated one day to do the final pretrial. Here we go. Go ahead.
Yeah, they do put, like on number 14, they put that the defendant objects filing written response. So probably the only ones that are going to be in dispute, unless they all are in dispute, I can't tell, that will be heard on Monday or whenever the judge hears the motions.
Well, what about number 15? Commonwealth's motion in limine, number 15, to admit internet history from devices in Walshe residence. Defendant objects, filing written response. So, there's some meaty stuff here. Here's a good one, number 16. The Commonwealth's motion in limine number 16 to admit evidence that on December 28th, 2022, defendant's mother hired a private investigator to investigate Ana Walshe's infidelity. Interesting. And of course, the defendant objects. Then we get to the defendant's motions in limine. Sequestration of witnesses. That's perfunctory. It's agreed to, so that'll be allowed. Regarding evidence that biological evidence is bone. Yeah, they've already dealt with that as far as I know.
Yeah.
Commendations. Oh, yeah, they don't want number 5. The defendant does not want the Commonwealth to brag about any commendations that officers have received. That's part of the basic
Building up of
introduction. Yeah, building up of a law enforcement witness to the jury, just giving background. I went to the police academy. I studied forensics. I specialized in X, Y, and Z. Have you received any recognitions? I would say that's pretty standard.
Yeah.
I think that's fairly standard.
You can use their credit. I mean, you can boost their credibility, and the defendant can attack the credibility of officers. So it's fair game.
Yeah. Defendant's motion, number 8, defendant's motion in limine to exclude defendant's request to consult with attorney or statements of prior counsel. Interesting. So, defendant's motion in limine to exclude pillow and pillowcase. Defendant's motion in limine to exclude dinosaur picture and teddy bear. All right, that's sad. And then the point is, there's just so many motions that are on this list. Now, some of them may have been agreed upon. Some of them, for example, one that says agreed, the court's going to allow that. That's a perfunctory matter. But just the number of issues that are still up in the air this close to trial. I mean, we're only a couple of weeks away, if that, to trial.
The other motions, the other pretrial motions, one was the change of venue, which was dealt with today or at the hearing.
Yeah. Motion for discovery regarding experts. Is this going to be one of those trials where they do, remember the Karen Reed trial, they actually did do some depositions in the middle of the trial. Remember that? That happens. It's not a good day. It's not a good day. Defendant's motion to continue trial. That's by the boards. That is the pretrial memo, and so they've got a lot of work to do. I was really surprised that Judge Freininger pulled out of her purse the ruling she had already made on the motion to change venue. But she's busy. She knows that this is a train coming down the track, and she's got to deal with it. I wonder how many other issues she's already resolved, and she's just ready to pull those out also. I mean, I don't know. I really don't know.
It's a lot of work. I mean, I'm sure maybe she has a judicial clerk helping her, but.
Sure. Although I've heard Superior Court judges say that they don't have enough help. I remember I was trying a case one time in the Essex County Superior Court, and there were I was going to say a couple, but there was really one issue that was really difficult to determine the difference between willful, wanton, reckless negligence and intentional acts and regular negligence. And there was nothing in the templates. There was nothing in the suggested jury. I mean, they have books full of these things, but there was nothing exactly on the way that had been raised in my case. And so we were called into chambers, and we discussed it, and we were told that the judge didn't have anybody helping him on this, and that we were both to brief it concisely with specific references to case law the next day. So we both did that, and we went in there the next day, and the judge had his laptop out. And this is what I mean when I say people don't paint with a broad brush and say the whole system is rotten, because it's not. And that good judge listened to both of us. They listened to me, they listened to the other attorney, and he sat there on his laptop and he hammered something out. And he said, "Are you guys happy with this?" Well, I wasn't happy. The other guy wasn't happy. So the judge, until he finally, neither one of us was 100% happy, as happens in court. That's why they call it an adversarial system. But he actually tapped it out on his laptop because he didn't have anyone to really help him with that. And so he did a jury instruction that we both ended up saying, okay, all right, because we got tired of fighting about it. And our differences weren't that big. So my point is, I would certainly hope that Judge Frenier has somebody to help her and to do the research and to, make sure that, she's got a solid ruling. I would say that the change of venue, you can agree or disagree, but I would say it was pretty solid. I mean, we spent a lot of time listening to her give us the citations of 425 Mass 233, page 5. How long can you listen to that if you're a non-lawyer? But anyhow, I digress. So our comments this week go to the episode that we did just several days ago on the sidebars as to all the efforts to get the sidebars out of the Karen Reed trial, which ended way back in June. And the sidebars have still not been disclosed. And we talked about the efforts of Corey Hopkins to get them. We talked about the Reed legal team's efforts. They filed a motion way back in July 30th. And Adam Lally finally filed a motion throwing up his hands and saying, "I need direction from the court. I'm confused." So that's what our viewer comments are on this week. That's what our viewer comments are on this week. And here they are. And do you want the odds or evens this week?
I'll take the evens.
Okay, so Kevin Fagan, C4T, says that at 3304, just below the highlighted text, it states, on March 31st, 2025, the court issued a memorandum of decision ordering, 1, the sidebar conferences will not be available on FTR. That's where the public gets to see things until after the trial has concluded. I realize this has already been stated by others, but here it comes directly from a prosecution filing, and I agree 100%.
Yeah. Okay. This is from Brenna O'Brien, T1P. First, congrats on 37,000. So happy Corey contacted you. I think Norfolk County DA's office wants to hold on to the sidebars for several reasons. In the first trial, knowing Laughlin and Lally and Cannoni all saying there was no exculpatory evidence in the federal documents, also due to the potential jury tampering allegation.
That's a really good point, Brenna. Brenna's a regular. She's down in the comments section, if not every episode, 9 out of 10. And that's absolutely right, that the prosecutors from the Norfolk County District Attorney's Office and the judge read these transcripts. There's nothing exculpatory in there. There's nothing to be seen here. Move along. And then Judge Krupp, in the Walsh case, actually, in a previous hearing in the Walsh case, wrote a little footnote at the bottom of the page that said, 19, there's 19 other cases that could be impacted here. 19. And then we had Mark Bederow on, and he said, it's not 19, it's 20, because my Aiden Carney cases could be on there. So anyhow, that was not a good day. Really not a good day. Okay, so 3, RTVR3CL. Where do people come up with these numbers? Do you really trust the government to redact anything and it be done right? I don't think so, especially in mass. Well, no.
Yeah. Okay, number 2, Hukejo or Hukejo.
I'm not helping you. I have no idea. I'm sorry.
Okay, it's okay. What is the point of judges having no speaking objections during trial? My understanding is so that the attorneys don't let the jury hear certain arguments, issues when stating objections, which then could be excluded by the judge from coming into trial, thereby causing prejudice to either defendant or the state. Once the jury delivers a verdict, all sidebars should be subject to and fulfilled by public information requests. Yes.
Absolutely. I couldn't agree more. Yeah, I mean, yes. Yes, and yeah, I agree. And most trials that I've been a part of, you do state the
Yeah.
grounds. You're not allowed to do it in an argumentative manner,
You just
but
state the objection, like hearsay or
exactly.
relevance.
So exactly something like that. And the judge, has been on the bench long enough that they know in their head whether it's a good objection or whether it's BS. Now, there are times when they do call you over if there's some issue that's not apparent and they want to think about it a little bit. But number one this week is from Emma Louise Avis. Can I rent a car? Just kidding. Emma Louise, 1510. Love listening to Alexis. Agree with you, Andrew, that she summed up the situation well.
did.
Liverpool, England. I love it. I love it. I love it.
Yeah, Alexis she's cute.
She's smart too. The funny thing about her is that she comes around and she says, We're not medical people. We're not attorneys. We're just people with opinions. And I love the way she says that. It's awesome. So this person is from Liverpool, England. Which we love it. We love it. Here's our list of 80 countries from whom we have had comments and questions. And I guess this really built up during the Karen Reed case itself. And at some point I said I was going to retire the list. But after I said we were going to retire the list, we got a couple of more countries. So we'll reopen it. And if you can freeze frame this and look, the countries are in alphabetical order. So if you are watching us from a country that is not on the list. I mean, we love hearing from you, like UK, you're already on the list, but let us know. But if you are not on the list, let us know, and we will certainly put it on the list. So at this point, we point out that, we do not sell merch. We do not ask for money. I don't have, even though people have approached us, I have not accepted any offers for commercials. I hate commercials, even though I worked in commercial TV for a while. So all we do is that we ask you to subscribe, and it's free.
You pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
Yoli, closing thoughts.
I'm looking forward to watching this trial if I can. I mean, I'm busy, but I look forward to watching this Brian Walshe trial or parts of it.
Yeah, I think I'll do the same thing that I did with the Karen Reed trial and wait until evening and then watch it. I'll guess. I don't know. It's only my speculation. I'll guess there won't be so many sidebars. I'll just guess.
You never know.
No. You want to move things along, and not because of us YouTube watchers, because of the jury. The jury is taken away from their normal lives, their families, their jobs, whatever. And if I'm on the jury, I want the case to proceed. I don't want them spending so much time in sidebars that I'm just sitting there, twiddling my thumbs. I mean, they're not allowed to bring the newspaper in. During the sidebar, they could, pick up a paperback or, they're not allowed to have their tablets, so they can't, go on their tablet and watch YouTube. So if I'm on the jury, I want the trial to go, continuously with as few interruptions as possible. And I will bet that there will be fewer interruptions in this trial. So that's my closing thought. Go down in the comment section. Let us know your thoughts. As I always say at the end, be kind. If somebody says something you don't like, this is a legal true crime channel, so we don't go down in the, the various areas that are kind of crazy. Don't call somebody a name if you disagree with them. Start a whole new thread and tell me why you disagree with another comment. Give us law, give us facts, tell us what you've read somewhere or seen somewhere that helps. So Yoli, have a good one. Good to see you again.
Talk to you later.
And be nice, everyone. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.